Your Lordships and participants, welcome to the first moot court competition of His Highness Maharaja's Government Law College, Ernakulam. Welcome team 104 and 114. If the teams are ready, both teams may convey your time apportionment right now. You can either unmute yourself or put it in the chat box.
IMC 104, the speaker 1 will take 20 minutes. The speaker 2 will take 23 minutes and 2 minutes for rebuttals.
Okay, thank you.
Am I audible?
Yes, you are.
IMC team 114. Speaker 1 will take 15 minutes and speaker 2 will take 50 minutes each. And for rebuttal, you will take 5 minutes.
So based on the apportionment of time suggested by the respective teams, team 104, speaker 1 will be taking 20 minutes for speaking, speaker 2 23 minutes, and the rebuttal time is 2 minutes. In case of IMC 114, speaker 1 will be taking 15 minutes, speaker 2 25, and the rebuttal time is 5 minutes. So let us begin with the session shortly. Once again, informing everyone that the current session will be live streamed on YouTube. We've begun with the live streaming.
Excuse me. Excuse me. Hello.
Yes.
Can I have a clarification? I'm team number 114. The two speakers will take 15 minutes each.
15 minutes each. Okay. And the rebuttal time is?
5 minutes.
Thank you for the clarification. So, your lordships and participants, are you ready? Shall we begin with the session?
Yes.
Thank you. Good afternoon, everyone. It's our esteemed privilege to have with us our judge for the semi-finals of first international moot court competition conducted by His Highness Maharaja's Government Law College, Ernakulam. We have here Advocate Madhu Madathil and Dr. Harishankar KS. Welcome, judges. For the attention of the judges, we have here team code IMC 104 and IMC 114. IMC 104 composed of speaker 1, speaker 2, and researcher representing the petitioner side, and IMC 114 composed of speaker 1, speaker 2, and researcher representing the respondent side. Hope all the participants have went through the rules, and both teams will be having a total of 45 minutes each for their presentation. Speaker 1 will be having 20 minutes, speaker 2 23 minutes, and the rebuttal time 2 minutes. In case of IMC 114, speaker 1 will be having 15 minutes, speaker 2 15 minutes, and the rebuttal will be 5 minutes. There will be a warning given for half time and at the end of 5 minutes, 3 minutes, 1 minute, and when the time slot is over. All of the instructions have to be adhered to by all the participants. And all of these instructions will be duly timely put up in the chat box. So make sure that you're monitoring it thoroughly. You may only continue speaking after seeking the due permission of the court, if at all you exceed the time limit. To those teams who have submitted the compendium, your IMC 104, please direct the court officers to present the same. The speakers may request the court officer for the screen sharing process. And please make sure that you're also telling us the due page numbers so that it will be easy for the code officers. If your lordships are ready, I would like to invite the first speaker for the petitioner to speak, IMC 104. Speaker 1, your time starts now. You'll be having 20 minutes.
The council seeks permission to begin with its oral submissions.
Yes.
The council seeks permission to refer the learned bench collectively as your lordships.
Yes, please.
Warm greetings, your lordships. May it please the court, this is council number 1, representing the petitioner in the instant matter of Octa Limited versus owners and parties interested in MB Moonlight. The council over the course of next 20 minutes shall be dealing with the substantive issues of the case, that are issue number 1 and 2, whereas my co-counsel would be dealing with issue number 3, 4 and 5. The council submits to the jurisdiction of this Honorable Mumbai High Court under section 4 subclause F of the Admiralty, Jurisdiction and Settlement of Maritime Claims Act 2017, which permits this Honorable High Court to exercise jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of any loss or damage to or in connection with any good. Now, if your lordships are well versed with the facts of the case, the council seeks permission to move on to the arguments advanced.
Yes, go ahead. Yes.
Indeed, your lordships. Your lordships, the council shall address the first issues in two parts, that are the international perspective and the Indian law on the issue. Firstly, the council shall touch upon the international conventions on maritime jurisdiction, which allow the domestic high courts to exercise jurisdiction over foreign seated arbitration tribunals. Your lordships, it is humbly submitted that prior to the enactment of Admiralty Act in India, the Supreme Court in cases like that of MVC success has always taken the assistance of international conventions to deal with the extent of jurisdiction of Admiralty courts in India regarding the foreign seated arbitration proceedings, and has observed that where no statutory law operates in the field, interpretive changes must be made having regard to ever-changing global scenarios. Your lordship. Now, lordships, firstly, the council would like the lordships to refer to page number 1 of the arguments advanced, point number 3, where the international convention relating to the arrest of seagoing ships has been cited, your lordship. Page number 1 of arguments advanced in the moot court memorial. Are your lordship with me?
Council, my concern is why do you have to refer to an international convention when you have a specific national legislation governing a particular issue?
Your lordships, it is humbly submitted that there is no specific legislation with respect to maritime law in India that requires an interim measure in case of an arbitration proceeding seated outside India, lordship. For that matter, it is important to refer to international conventions, your lordship.
Can you elaborate on what do you mean by interim measure? And is this an interim measure?
Your lordship, interim measure is if there is an arbitration proceeding seated anywhere and the petitioners have requested for a stay to those arbitration proceedings or to bring into the jurisdiction of this to file a case in this honorable court, that would be the interim measure, your lordship, in this present case.
So
the petitioners having.
Yeah, counsel, two things. So your essential argument is that there is an arbitration ongoing. There is an arbitration.
No, your lordships, there is an arbitration clause in the agreement, your lordship.
So just merely because of an arbitration clause in an agreement, you are saying that any claim which goes to a high court or any court of law can be termed as an interim measure?
Your lordships, no, your lordships, an interim measure would be the power of this court to grant protection from the arbitration clause, your lordship. so that we can
From
pursue
the
a course in this
arbitration,
honorable court.
that's precisely my concern. From the arbitration clause or from the arbitration process.
Arbitration process, Your Lordship.
So you essentially saying that there is an arbitration going on.
No, Your Lordship, there is no arbitration clause that has been invoked in the present case.
Then why do you seek for ask for an interim measure?
Sir, Your Lordships, the main argument by the council is that the jurisdiction of this present court should be in this present case, Your Lordship. The case should not be referred to the arbitration clause.
I'm not saying that we don't have jurisdiction. So my first question was, when you have a national act
Your Lordship.
dealing with this question, why do you have to refer to an international convention or a treaty?
Your Lordships, the National Act is not specific to Admiralty cases, Your Lordships.
Which national act are you referring to?
Your Lordships, the Section 9 of the Arbitration Act,
But we
which
have
provides for a...
We do have the Admiralty Act, right?
Yes, indeed, Your Lordship.
Yeah, what does it say?
Your Lordships, there is no as such provision that says for a foreign seated arbitration, there could be the court could pursue the present case if there is a foreign seated arbitration, Your Lordship.
There is no foreign seated arbitration. You're just saying that there is a clause in the contract or in the charter party.
Indeed, Your Lordships, but there is the clause says the party should be referred to arbitration in a foreign seated outside India, Your Lordship. With respect to that.
Okay. So do you have any mention of in the arbitration? Sorry, in the Admiralty Act, do you have any mention of this conflict of jurisdiction?
Your Lordship, the Admiralty Act under Section 4 subclause F permits the High Court to exercise jurisdiction to hear any case of a maritime claim, Your Lordship.
All right. Yeah. Move on.
Indeed, Your Lordships. My Lordships, the two important conventions in this regard are the Article 7 subclause 1 subclause B of the International Convention relating to arrest of seagoing ship. It explicitly states that the courts of the country in which arrest was made shall have jurisdiction to determine the case upon its merit if the domestic law of the country in which the arrest is made gives jurisdiction to such courts. Your Lordships, similarly in the present case, the Section 4 subclause F of the Act permits the High Court of Mumbai to exercise jurisdiction to hear and determine any question on a maritime claim, Your Lordship. Furthermore, Your Lordships, on point number 4, the Article 2 subclause 3 of the International Convention on arrest of seagoing ship is stated, which states that a ship may be arrested for the purpose of obtaining security, notwithstanding that by virtue of a jurisdiction clause or arbitration clause in any relevant contract, Your Lordships. Your Lordships, this article explicitly allows the vessel by any court to obtain security regardless of the fact that there exists a clause in the contract directing any future disputes to be adjudicated in any other state other than the present state, Your Lordship. The convention contains lucid provisions allowing the parties the right to initiate an action in rem on pending foreign seated arbitration proceedings, Your Lordship. Hence, Your Lordships, it can be rightly stated that the two conventions unequivocally authorize the arrest of vessels and other similar properties under this Honorable High Court's Admiralty jurisdiction to present as a security for pending international arbitrations, Your Lordship. Now, Your Lordships, moving on to the second sub-issue. The second limb of my argument states that it is humbly submitted that the Arbitration and Conciliation Act of 1996 does not oust the jurisdiction of a civil court, Your Lordship. The Section 9 of the Arbitration Act states that a party may, before the commencement of arbitration proceeding, apply to a court for interim measures, Your Lordship. The subsection 2 of the section lists down that a party may apply for interim measure for the detention of any property which is the subject matter of dispute in arbitration. Now, Lordship, it is very important to state a case related to maritime law here. That is the JS Ocean Liner versus MV Golden Progress. In this case, Your Lordships, the same Honorable Mumbai High Court rightly concluded that a vessel can be arrested and the detention can be made under the Admiralty jurisdiction of this court, even if an arbitration agreement with a foreign seated arbitration exists. The Honorable Court observed that an action in rem as an Admiralty suit for recovery of maritime claim and arrest of vessel in exercise of Admiralty jurisdiction can be maintained even when there is an agreement in place, Your Lordship. Hence, your lordships, in the present case, the arbitration proceedings have not started, and an admiralty suit for the enforcement of maritime claim falling under Section 4 of the Admiralty Act has been provided. Hence, your lordships, citing one more case here, that is the case of MV Elizabeth, it has been rightly stated that this honorable court has unrestrained power unless there exists a clear provision barring the same, your lordship. The charter party in the present situation does not explicitly prohibit either of the parties to approach the admiralty jurisdiction of the present court, your lordship. The court in the exercise of such power can pass interlocutory orders for arrest and attachment before the judgment in interest of justice. This unrestrained power of the court shall also include the power to arrest a ship and exercise its admiralty jurisdiction. The very basis of exercising this maritime claim would be wholly frustrated if the statute is so interpreted as to deprive a maritime petitioner the rights which he hitherto enjoyed and enjoys in other country as per the two conventions. Thus, your lordships, after a comprehensive study of past judgments, international conventions, it is humbly submitted that the High Court of Mumbai has the authority to exercise its admiralty jurisdiction in the present matter. Your lordships, the council seeks permission to move on to the second issue.
So in my understanding, there is one more judgment of the same court, the Supreme Court, which says that in case of foreign seated arbitration, whether it has been started or not, Indian courts shall not have jurisdiction.
Indeed, your lordships.
The
Your
case I'm
lordships, this
referring to is Bharat Aluminium case.
Indeed, your lordships. Your lordships, the Balco judgment was announced pre-2015 amendment of the Arbitration Act. The 2015 amendment of the Arbitration Act extended the jurisdiction of a court to foreign seated arbitration agreements, your lordship. Before that, it was only the Indian seated arbitration. It was extended to foreign seated arbitration after the 2015 amendment.
So you mean to say that all courts in India shall have jurisdiction on all the foreign seated arbitrations after the?
Indeed, your lordships, as per the Arbitration Act.
For all cases of, so for example, this is probably off topic, but if you have an arbitration award from London Arbitration Tribunal, can you go and annul the award, the Indian court?
Your lordships, an award and an interim stay are two different things. But even to your question, your lordship.
But your explanation was 2015 amendment allows all sorts of jurisdictions, right?
Your lordships, the main purpose of 2015 amendment was to extend the part 1 of the Arbitration Act to foreign seated arbitration tribunals.
Yeah, part 1.
First, it was that only part
1. I mean, annulment comes under part 1 only.
Could you repeat, your lordships?
Annulment of an arbitral award comes under part 1.
Indeed, your lordship. Part 1 and part 2 have now been extended to international arbitration tribunals. First, it was only the part 2.
All
now, if your lordships do not have any preliminary queries, the council seeks permission to move on to the second issue. Sure. Much obliged. Now, your lordships, moving on to the second issue, the council humbly submits that the declaration of journal average is not legally sustainable if the vessel is unseaworthy. The petitioner forwards the following arguments in furtherance of their contention. Firstly, your lordships, the vessel not being able to cope up with bad weather makes it unseaworthy. It is further submitted that the vessel not being able to cope up with bad weather makes it unseaworthy, and it is the failure of the owners to exercise due diligence to make the vessel resistant of situations like bad weather, and the inadequate training of the master led to the loss of cargo. Your lordships, in its most fundamental sense, providing a seaworthy vessel requires the vessel being structurally fit for the intended voyage. Structurally fit would mean that the vessel is fit to meet and undergo the perils of the sea and other incidental risks to which of necessity she must be exposed of in the course of a voyage. The same has been listed under section 41 of the Marine Insurance Act. Structural fitness typically entails some attribute of the ship itself, which makes her unseaworthy, and a vessel will not be seaworthy if she is unable to cope up with common phenomena like that of stormy weathers or rough seas. Your Lordships, now it is a well-known fact that a master's cabin is always located on the starboard side of the vessel. If we observe from behind the vessel, the right side would be the starboard side, whereas the left side would be the port side. Now, the right side, that is the starboard side, is the giveaway side in ROR, that is the rule of road. And captain is expected to see the traffic on starboard side of his ship, just to be aware of this traffic situation where it is his ship's duty to take action. The fact that the vessel listed 35 degrees starboards proves that the master failed to scrutinize the situation quickly and took rash decisions. Your Lordships, if your Lordships could refer to the page number 9 of the compendium, there are two tests that have been referred on the page number 9 of the compendium. Page number 9. Right, the maneuverability trials, a second point. Your Lordships, before the commencement of any voyage, the vessel undergoes maneuverability tests.
Sorry. Yeah. Because I was referring to the memorial that you sent. Now I have it. Yes.
Indeed, Your Lordships. The screen is being shared. On the second point, before the commencement of any voyage, the vessel undergoes maneuverability tests to ensure safe navigation under worst case scenario. The rudder is always tested from 35 degrees to 30 degrees. Starting from a straight motion at the speed, the rudder is turned to 35 degree or maximum rudder angle permissible and kept at this angle until or unless the ship has performed a turning circle of at least 540 degrees. Now, Lordship, this test is conducted for both the starboard side and the port side. Hence, enlisting of the vessel of 35 degrees starboard presents no threatening situation. It is something for which the vessels are generally prepared for in the first place. Additionally, Your Lordships, all ships today are fitted with marine forecasting equipment to measure the speed of air to forecast sudden changes, in addition to weather buoys that move across the ocean and give timely updates as to what the weather is. Now, Your Lordships, had the owners exercised due diligence and made the vessel seaworthy, the loss of cargo would have been avoided. Hence, Your Lordships, it is humbly submitted that the unseaworthiness was the direct cause of the present predicament. Unseaworthiness being the result of owner's fault emancipates the petitioners from payment of general average security. Hence, the owner's demand of general average security is not legally sustainable. Now, Lordships, moving on to the second sub-issues. The council seeks permission to move on to the second sub-issues.
So the contention is that the vessel was seaworthy at the time of start of the voyage.
Your Lordships, the contention is that the vessel was unseaworthy. That is why the master had to jettison such a huge amount of cargo. It was the skills of the masters that are at question here, Your Lordship, which is also an aspect of seaworthiness.
Counsel, my learned brother is asking, was it seaworthy at the time of the start of voyage? If it was seaworthy, then why it was unseaworthy, then why would you go for a contract like this?
Your Lordships, the council humbly submits that the vessel was seaworthy at the commencement of the voyage, but there are two aspects to seaworthiness, Your Lordship. One is the physical seaworthiness and second is the human seaworthiness. The human seaworthiness includes the skills of the masters and the crew. Your Lordships, the main contention here is that even if the vessel was seaworthy at the first place, it is because of the master deciding to jettison such a huge amount of cargo, which makes the vessel unseaworthy in the present case, Your Lordship.
Okay, so again, the argument is that because it was found unseaworthy, you are not liable to contribute to the general average.
Indeed, Your Lordship. Your Lordships, here I would like to state a case which is in favor of this argument, Your Lordship. The case is the Thor Commander case, Your Lordship, in which the owner of the ship Thor Commander had failed to exercise due diligence during the voyage to make the ship seaworthy. Now, Lordships, the failure to exercise due diligence is a violation of Article 3, Subclause 1, Subclause A of the Hague-Visby Rules. And therefore, the owner of the cargo was not obliged to contribute to general average. The losses sacrificed were caused due to the actionable fault of the owners of the vessel, Your Lordship. Hence, Your Lordships, it is humbly submitted that the unseaworthiness was the direct cause of the present predicament. Having cited the Hague-Visby rules, unseaworthiness was a result of the owner's actionable fault, which emancipates the petitioners from the payment of general average in the present case. Hence, Your Lordships, it is humbly prayed that the owner's demand for general average is not legally sustainable in the present case. If Your Lordships have any preliminary queries.
No, go ahead. There is a direct judgment by the English courts, CMA, CGM, Libra.
Indeed, Your Lordship.
Have a look at it, and it directly supports what you've just submitted.
Yes, Your Lordship. The same has been cited in the moot court memorial. Due to paucity of time, the council could not refer to the same. Now, if Your Lordships are satisfied, can the second council please proceed with his arguments?
Okay.
Much obliged, Your Lordships. It was indeed an oral argument before you.
Am I audible, Your Lordships?
Yes.
Greetings, Your Lordships. This is the Council number 2, representing on behalf of the claimants, Octa Limited. The Council, over the course of the next 23 minutes, will be dealing with the issues in the order of first, issue number 4, then issue number 5, followed by issue number 3. With your permission, Your Lordships, the Council may begin with the issue number 4.
Yeah.
Lordship, the issue number 4 states that since the claim for short delivery of cargo is raised before the court, where a counterclaim is also raised by the owners demanding GA contribution, whether the court can adjudicate on the rival claims, considering the fact that the alleged damage occurred within its territorial waters. Your Lordships, the petitioners contend that the court should not adjudicate on the counterclaim filed before the court, and the council puts forth the following contentions in its favor. The council would like to begin the issue by defining counterclaim as stated in the Code of Civil Procedure. Your Lordships, counterclaim in Order 8, Rule 6A of Code of Civil Procedure 1908 is defined as a defendant by means of a counterclaim can claim any form of a right or claim with respect to a cause of action that accrues to the defendant against the claim of the plaintiff. Lordships, the council would like to refer your Lordships to the moot court memorial under the arguments advanced on page number 12, point number 53. If your Lordships could refer to page number 12, point number 53.
Yes, please.
Should I proceed?
Yes, you can. Yes.
Much obliged, Your Lordships. In the case of Bow McLachlan and Co. versus Ship Camuson, the Supreme Court of Canada observed that a counterclaim is substantially a cross-sanction and not merely a defense to the plaintiff's claim. Lordships, it is humbly submitted that the counterclaim raised by the defendants demanding general average contribution is merely a defense to the claim raised by the claimants of short delivery of cargo and is not an independent cross-action suit. Lordships, the short delivery of cargo was caused by the defendants when the ship was in peril during its journey, as it had listed by 35 degrees to the starboard side, which is the right side of the ship. As a result, Your Lordships, the master of the vessel decided to jettison some cargo, and the defendant, due to the loss of cargo, demanded general average contribution. It is important to note, Your Lordships, that in the facts of the present case, the owners of the ship did not release the cargo for the claimants on reaching the destination at the Mumbai port, stating that the claimants are bound to pay for the general average. It is also mentioned in the facts of the case, Your Lordships, that the claimants had then paid the general average to the owners of the ship through their cargo insurers. Your Lordships, the fact that the petitioners have already paid their part of the general average contribution immediately proves that the counterclaim raised by the respondents demanding general average contribution is invalid. Since the petitioners have already paid their contribution, the counterclaim raised is clearly a defense to the claim raised by the plaintiffs of short delivery of cargo and cannot be concluded as a separate suit to pursue. Also, Your Lordships, according to Rule A, Clause 1, which is referred under the arguments advanced on page number 11, point number 47, Rule A, Clause 1 of York and Foop Rule states that there is a general average act only when there is an extraordinary sacrifice or an expenditure is intentionally made for the common safety of the purpose of preserving from peril the property involved in the common maritime adventure. Also, Your Lordships, on the same page, on page number 11, point number 48, Rule D of the York and Foop Rules states that the right to contribution in general average shall not be affected, but this shall not prejudice any remedies or defense which may be open against the party in respect of such fault. Your Lordships, it is humbly submitted that according to this rule, the Rule D of York and Foop Rules, the claimants are free to use any defense which may be open against the demand for general average by the defendants. Since the general average has already been paid, as mentioned in the facts of the case, the counterclaim raised for the demand of general average cannot be considered as a cross suit. And according to Rule 6C of Order 8 of Code of Civil Procedure, which is referred to in the Moot Court Memorial under Arguments Advanced, on page number 11, point number 50, shall I proceed?
Yes, please.
According to Rule 6C of Order 8 of CPC, the plaintiff can contend that the counterclaim raised by the defendants should be excluded and ought not to be disposed of by way of counterclaims. Therefore, according to this rule, Your Lordships, the petitioners contend that the court should not adjudicate on this counterclaim. If Your Lordships have any preliminary queries, the council would like to move on to the fifth issue.
Just a factual concern. So where is it stated that you paid your contribution of general average?
Your Lordships, it is mentioned in the...
My understanding, you paid the security, right?
And the general average also.
Maybe I'm missing
Your Lordships, it is mentioned in the Moot Court proposition in page number 3, in the last paragraph of page number 3. It is stated that the petitioners had paid the general average to the defendants through their cargo insurers.
No. Counsel, general average, what happens is the cargo insurers put up security and the actual general average is decided at a later stage. So what has happened now is, as the problem will indicate, the cargo insurers have put up general average security. So if a 5% or a 10% is sought for, so you put up the security, and which will be later on adjudicated by the average adjusters. So you have not paid the general average. You've just paid or put up a security for GA. Anyway, go ahead.
Yes, Your Lordships.
No, if you have all the basic question is, if you've already paid the general average, then why is there a dispute? And your co-counsel also argued that it is paying the general average is legally unsustainable.
Yes, Your Lordship.
Then why did you pay that? And if
Your
you paid
Lordships,
it, there is no dispute.
Your Lordships, the problem occurred when the cargo was reached its destination at the Mumbai port, and the owners of the ship did not allow the claimants to take back their cargo. They had halted the process of release of cargo, and so that the claimants could receive their cargo, they had to pay the general average to the defendants. Otherwise, they couldn't have gotten their cargo back. That's the reason they had to pay it, even though they believe that it is unsustainable.
So now you are asking for a refund of your contribution. Is that your case?
No, Your Lordship, that is not the contention of the petitioners.
What is your contention?
Your Lordships, in issue 4, they have just stated, the petitioners have stated that the counterclaim should not be adjudicatable by the court.
Okay.
Your Lordship, the council would like to move on to the 5th issue then.
All right.
Much obliged, Your Lordships. Your Lordships, the 5th issue asks whether the provision of the Arbitration Act would exclude an action in rem from its purview as non-arbitrable. The petitioners contend that action in rem is excluded from the purview of Arbitration Act as non-arbitrable, and the council puts forth the following arguments in its favor. Lordships, the Arbitration and Conciliation Act 1996 does not define arbitrability. Neither does it specify any set of disputes to be non-arbitrable. Hence, the law in this regard has developed largely through judicial pronouncements. Lordships, in Booz, Allen and Hamilton versus SBI Home Finance Limited, Lordships, the council would like to ask the court officer to refer to the compendium on page number 29, paragraph 37. Page number 29, paragraph 37. So on page number 29. On paragraph 37, the second line states that the Honorable Supreme Court had explained action in rem and action in personam as a right in rem is a right exercisable against the world at large, whereas a right in personam is one exercisable against specific individuals. On the same page, on paragraph 38, the first line, the court had concluded that traditionally all disputes relating to rights in personam are considered amenable to arbitration, and all disputes relating to rights in rem are required to be adjudicated by courts and public tribunals, being unsuited for private arbitration. Lordships, in a more recent case of Vidya Dharolia versus Durga Trading Corporation, which is referred in the moot court memorial under the arguments advanced on page number 30, page number 13, point number 61. If your Lordships could refer to the moot court memorial. Page number 13, point number 61. Are your Lordships on the page?
No
Yes,
need.
please.
You can go ahead with the argument.
So on the 4th line, it is stated that a 3-judge bench of the Supreme Court in 2021 was required to determine the arbitrability of landlord-tenant disputes. The court had emphasized that when the cause of action is in rem, then the dispute would be non-arbitrable. There are also other instances where courts have rejected the plea for arbitration on the ground that the matters contained an action in rem. In the case of Indian Performing Rights Society Limited versus Entertainment Network, which is referred to in the arguments advanced on page number 14, point number 64, third line, the Bombay High Court had stated that a party, even by consent, cannot confer jurisdiction on the arbitral tribunal in case of an action in rem. Hence, your Lordships, since the Arbitration Act does not specify any set of disputes as non-arbitrable, and the law in this regard has developed largely through judicial pronouncements, therefore, according to the case laws mentioned stating action in rem as non-arbitrable, it is humbly submitted before the court that an action in rem is excluded from the Arbitration Act as non-arbitrable.
Counsel, so why do you think an action in rem is non-arbitrable? And in this specific context, the same question, why do you think we should consider it as a non-arbitrable issue?
Lordships, as explained by the council in Booz, Allen, Hamilton versus SPM.
You have not explained it completely. You've taken some abstracts for your convenience, but there are other paragraphs in the judgment which says that if there is a right or an action in rem, which is subordinate to the action in if there is a subordinate action in rem rising out of an action in rem, that can be arbitrable. So in this context, even if it is a case against the ship, the res, there could be a possible action against the person, the ship owner, right? So in such a situation, is it possible for a court to, sorry, for a tribunal, arbitral tribunal to arbitrate the matter?
Your Lordships, as the court had mentioned that subordinate rights in personam that arise out of action in rem can be settled in arbitration. That is true. That can be done. That's a specific situation under the category of action in rem that can be arbitrable. However, Your Lordship, in the present case, that is not the case. In the present case, the issue number 5 specifically asks whether an action in rem is arbitrable or not, according to the purview of the Arbitration Act 1996. Lordship, the Arbitration Act does not specifically exclude any categories and exclude any category of.
No, counsel, just tell me if you agree that if there is a subordinate action in rem possible, it is arbitrable, right? And why do you think that this context is not a fit case for that? Why do you think that there is no subordinate right in personam here?
Your Lordships, the court had not specifically explained in proper the meaning of that statement that if there are subordinate rights in personam that arise out of action in rem, then they would be arbitrable. Your Lordship, there is no signaling that there is a subordinate right in personam that is arising in our present case. And through that, the action in rem would be eventually arbitrable in an arbitral tribunal. Hence, in this present case, the action in rem would not be arbitrable.
So do you want the court of law to explain every jurisprudential concept? Then only you can, so if your argument is that Boosalan has not explained what is a subordinate right in personam, that is a jurisprudential concept, right? An action in rem and an action in personam, right? So my only question is, if you understand what is an action in rem and what is a subordinate action in personam, is this a possible case or any maritime claim for that matter? Because your claim is against a ship, essentially, that is your action in rem. But can there be an action in personam also, subordinate to that?
Lordship, the counsel would like to take a moment.
Sure.
Your Lordship, the subordinate right in personam requires a proceeding against a person and not a ship. And in the present case, the action was taken against the ship, as mentioned in the moot court proposition. The ship was arrested. Originally, the ship was arrested, and then the security was given. So there is no subordinate right in personam that exists in the present case.
Who deposited the security for the release of the ship?
Your Lordship, the defendants had.
So they have rights in personam, right?
They had eventually submitted to the jurisdiction, so the claimants can proceed against them in personam. Yes.
Which means that those matters are arbitrable.
Indeed, Your Lordships.
Okay. Move
on. Much obliged, Your Lordship. The council would like to move on to the third issue. Your Lordship, the third issue asks whether the court is bound by sanctions imposed by a third country. The petitioner contends that the court is not bound by the sanctions imposed by a third country, and the council puts forth the following arguments in its favor. The council would like to begin the issue by explaining the sanctions, in this case, the STN list sanctions imposed by the United States of America. Lordships, the Office of Foreign Assets Control, or OFAC, is a US Treasury Department agency which administers and enforces economic and commercial trade sanctions against states, organizations, and individuals. These sanctions are based on the US foreign policy and national security objectives and are imposed on them who violate such policies. The entities on whom these sanctions are imposed are described by OFAC as specially designated nationals and are included in the STN list. The consequence of being sanctioned is that all US persons are prohibited to make any transaction with such entities included on the list. Not only that, but even non-US persons who are beyond the territorial jurisdiction of the United States are also prohibited from transacting with entities mentioned in the STN list. This prohibition on non-US persons is known as secondary sanctions. Lordships, these secondary sanctions are very controversial in nature since it requires a country to apply its laws extraterritorially to persons beyond their territorial jurisdiction. Your Lordships, the consequence of violating such sanctions is that the violator is blocked or cut off from accessing the US dollar denominated financial markets and may even be placed on the STN list. Lordships, the US economic sanctions are opposed by most countries for this very reason, that is, their extraterritorial reach, which is deemed to be a massive overreach in a world of equal nations. However, Your Lordships, it is important to note that under international law, states are still allowed to justify their extraterritorial jurisdiction under a few principles. Lordships, there is a principle called protective principle, which allows states to apply their jurisdiction in a foreign state for a crime that threatens the security of the former state. Lordships, in the present case, the petitioner paying to the defendant, as mentioned in the proposition, it is mentioned that the petitioners had settled the loss of cargo through insurance, which does not threaten the security of the United States in any way. Hence, the protective principle cannot be applicable here. Also, Your Lordship, another principle is the effects doctrine, which comes under the territorial principle. The territorial principle states that each nation possesses an exclusive jurisdiction within its own territory. The effects doctrine regards conduct that, even though carried out abroad, produces a direct, substantial, and foreseeable effect in the state asserting jurisdiction. Lordships, in the present case, the petitioner company had settled a cargo claim with the insurer, which does not cause any direct or substantial effect, less a harmful one, within the territory of the United States in any way, as the effects doctrine is also not applicable. Since, Your Lordships, all the principles which could possibly justify the use of extraterritorial jurisdiction by the United States are not applicable here, hence the secondary sanctions are not only against international law, but also do not have any means to be applicable on foreign countries. Lordships, the Permanent Court of International Justice in 1927, in the case of France versus Turkey, which is referred in the arguments advanced of the Moot Court Memorial on page number 9, point number 38. If Your Lordships could refer to the page number 9, point number 38, on the second line, the Permanent Court of International Justice stated that the first and foremost restriction imposed by international law upon a state is that it may not exercise its power in any form in the territory of another state. Your Lordships, also regarding foreign policies, the International Court of Justice in the case of Nicaragua versus United States, which is referred in the memorial on page number 9, point number 40, the International Court of Justice stated that the formulation of foreign policy is a matter in which each state is permitted by the principle of state sovereignty to decide freely. Hence, Your Lordships, since all the principles of jurisdiction that could have justified the use of extraterritorial jurisdiction by the United States is not applicable in the present case. And according to the judgments of the Permanent Court of International Justice, that no state may exercise its power in the territory of another state, it is humbly submitted before the court that the court would not be bound by the sanctions imposed by a third country. If Your Lordships have any queries, then the council will...
Just a general concern. Why do you think the decisions of the International Court of Justice, decisions pertaining to public international law, are applicable in a case essentially relating to private international law, like an admiralty suit?
Your Lordship,
my concern is, why do you have to refer to that?
Lordships, the judgment of the Permanent Court of International Justice,
as well as ICJ, both
as per
Lotus and Nicaragua.
Your Lordship, the judgment of the ICJ will be applicable in the present case because the subject matter of STN list is not a matter of private international law, it is a matter of public international law. because the extraterritorial jurisdiction that is used by the United States of America goes against the customary international law. And hence the International Court of Justice gave a judgment regarding the same, that the formulation of foreign policy is a matter in which each state is permitted by the principle of state sovereignty to decide freely.
Maybe I'm not an expert on this, but could you elaborate? What is your concern from that list? I mean, why do you think that the United States of America is going to apply this extraterritorial sanction on a? This is against a marine insurance company, right?
Yes, Lordship.
Yeah. So it's essentially, for me, essentially a private international matter.
Your Lordships, the reason the United States of America imposes sanctions is because the violator has violated the foreign policy or the sanction policy, or has threatened the economy of the United States. And that is the reason why the United States imposes sanctions in the first place. In the present case, the insurance company has been put on the SDN list. However, Your Lordship, could you please repeat your question? What your question was?
No, my question is why and how and why would it be a concern for you as a party or somebody who is supporting the marine insurance company, because the company insured your claim, right?
Yes, Your Lordship.
Claimant's claim. So if at all the US, I mean, I don't see any reason why the United States of America, unless you have all those economic sanctions, even though it is applied against a particular company, and there's not been any mention of such a sanction in the mode proposition. So I don't understand why is it a concern for you. And okay, so even if it is a concern for you, could you please give us some judgment which or any decision of a foreign court or even an international court which actually refers to these sanctions, rather than going into the extraterritorial application of jurisdiction, etc. Because both Lotus and Nicaragua has I don't think any relevance to this particular kind of sanctions, the SDN list that you're referring to, right? So if you have a more relevant, pertinent decision, either from a US court or from an international court, that makes more sense.
Your Lordship, you're asking for a international judgment regarding what exactly?
The list that you're, the sanctions, because otherwise you're taking it to the level of extraterritorial jurisdiction and public international law. I don't think which is relevant here. For us, we are dealing with a private international law issue. Now, if you are connecting it with public international law, it would be better if you can give us some more relevant decision applying the SDN list, rather than referring to Lotus or Nicaragua of ICJ. Anyway, if you don't have it, no problem, you can go ahead.
Just to add to that, two concerns. One, the ship called a country which is sanctioned, which is not extraterritorial. This is part of the voyage. 3 BLs have been issued for carriage from a country which is sanctioned, and there has been a claim. That is the first, which is a clear breach of the CP. Secondly, the cargo insurance is the insurer is a company based in a country which is under sanction, and the payment for the cargo is paid out by that insurer. So I beg to differ there. Two concerns which are directly in line with the sanctions. However, you've been, as a claimant, you've been paid by the insurer. So what is the concern, and why is it being submitted that sanctions don't apply to a third party, a third country?
Much obliged, Your Lordship. Much obliged, Your Lordships. The contention is that when any individual or an entity makes a transaction with an entity which is present in the STN list, that entity is also sanctioned. The United States imposes a sanction on that entity as well, and that entity is also included in the STN list. So the petitioner has this worry that they might also be included in the STN list. However, the petitioner believes that the sanctions imposed by the United States of America has the extraterritorial jurisdiction that is being applied by the United States of America is not legal as part of the customary international law. Hence, the petitioner contends that the court will not be bound by the sanctions imposed by a third country.
Okay, go ahead. Okay.
If your lordships have no further queries, the council would like to move on to the prayer.
Without interrupting the court,
Much obliged, your lordships. It is most humbly.
Is someone speaking?
if you want any more time, please seek permission.
Permission for the council to finish with the prayer.
Yeah, go ahead.
Much obliged, your lordships. Lordships, it is most humbly prayed before the Honorable Court of Mumbai that in the light of facts mentioned, arguments advanced, and authority cited, the Honorable Court may be pleased to adjudicate and declare that the Admiralty jurisdiction of the court is valid, the declaration of general average is not legally sustainable, the court is not bound by the sanctions imposed by a third country, the court cannot adjudicate on the counterclaim raised by the respondents, and the provisions of Arbitration Act excludes an action rem as non-arbitrable, and any other relief that the Honorable Court may be pleased to grant in the interest of justice, equity, and good conscience. It was an honor arguing before the court, your lordships.
If your lordships are ready, I will move on to the court.
Yes, please.
IMC 114, representing the respondent side, speaker 1 and speaker 2 each will be allotted a time of 15 minutes based on their time portion. Speaker 1, your time starts.
Am I audible, your lordship?
Yes, please.
This is council number IMC 114, your lordship. With your permission, I would like to directly enter to the statement of facts briefly, your lordship. Much obliged, your lordship. Am I audible?
I think we can go ahead with your submissions. We are clear with the facts.
As your wish, your lordship. If I may please, your lordship, I will go ahead with the first issue, with your permission. In view of the arbitration clause of the charter party, the exercise of admiralty jurisdiction by the court is not valid. Your lordship, I would like to invite your kind attention to the fact that the charter party agreement was entered in NYPE form, New York Produce Exchange, your lordship. This is a time charter party agreement. So, your lordship, after entering into this agreement, the two parties also entered in a clean fixture, which means, your lordship, you may have been more knowledgeable than me in that matter. The clean fixture means no addition and no removal of any article or any rules in that charter party on the agreement shall be made. So, your lordship, there is a clean fixture between the two parties. So, existing the clean fixture between these two parties, the Octa Limited, the petitioner here has to come to the London, has to make this argument in London for arbitration instead of seeking for arrest of the ship in this instance case, your lordship, in front of this honorable court. The lordship, if any dispute arises under this charter general average arbitration in London, it is to be applied in London and Lloyd. So the exercise of admiralty jurisdiction by this court would be valid, but there is a clean fixture and two parties are agreed in good faith and good intention to arbitrate this matter in London if any dispute, your lordship, arises between them. So that concludes the first issue, first argument, your lordship. Am I satisfied you? May I deal with the second one?
Okay, let me seek some clarification on your argument. Now, a clean fixture means only that the parties have confirmed a contract of carriage. So it is not that, okay, parties negotiate and there are no further restrictions on the charter party. Now, the charter party has an arbitration clause under UK, where the parties are free to go to for arbitration, while the claimant has approached this court for security, not for litigation or not for submitting the claim. He's approached this court only for security. You're free to dispute it under the merits in the arbitration proceedings, even when taken.
Your Lordship, there are some discrepancies in this matter. Your Lordship, actually, this claimant party, the petitioner here, had made our party, the owner of the vessel, come into contract with an insurance company who's blacklisted by America. Yes, Your Lordship, indeed, that America is a third country and Indian courts and Indian legal system is not bound by American law. But Your Lordship, I invite your kind attention to the matter that this vessel is an international sea-going vessel. In future, they will have to deal with a lot of contracts.
Counsel,
So-
we are on the question of jurisdiction. Let's go step by step. So why do you think that this court has no jurisdiction? That's a concern when there is an arbitration clause mentioned under the charter party. And as my co-judges rightly mentioned, this is not a question on the merits that we are going to discuss, right?
Yes, Your Lordship.
Do you agree with that? And you will have the time to dispute it before an arbitral tribunal. So why do you think that the existence of an arbitration clause bars the jurisdiction of an admiralty court?
The counsel would like to have some time, Your Lordship, referring the memo.
Sure.
Oh, your permission. Your Lordship, I would like to invite your kind attention to the fact itself that the claimants, the petitioner here, had made a series of mistakes by in the term of giving the security for the general average and in not contributing to the general average in due course, Your Lordship. And after all these things, the London arbitration, even the London arbitration clause exists there. So why do they have to enter into an Indian court to arbitrate to make this matter some worse? There are an arbitration clause, Your Lordship. So the arbitration clause is agreed upon by the two parties. That's why our party, the respondent team, makes the point here. That's a point that we would like to make, Your Lordship.
Okay, move on.
With your permission, the second issue deals the declaration of general average is legally sustainable. Your Lordship, this is all about the seaworthiness and unseaworthiness of the ship. The first and primary question is that our learned opposite counsel has argued that the ship was unseaworthy. Even if the ship was unseaworthy, why do they have to come into contract with our party? And Your Lordship, throughout the world, that if a charter party agreement is made, the ship owners will provide some certificates, which is the certificates of the seaworthiness of the ship. Your Lordship, the owner has the responsibility, as well as the party who comes into contract to make the charter party has the responsibility to make that sure that the ship was unseaworthy at the time of the beginning of the voyage. So this ship was seaworthy because they come into contact with this party. Your Lordship, after that, there is another thing that the NYP form, the Charter Party Agreement clearly stated that both of the party agreed that the ship should not go to any war zone. And upon the direction of the Octa Limited, the petitioner here, they themselves send the ship, and it's not the word send which is more suitable here, Lordship. It is directed the ship to go to the politically unrest Iran. So there is a grave mistake from the part of the petitioner. They directed the ship to go to Iran. So by directing the ship go to the Iran, they impliedly they agreed that if any part of the ship comes to damage, they will suffer. That's what they mean, Your Lordship. You are more
Counsel, suppose if you had a prudent master on board, even if somebody instructs you to go to a war zone, and the charter is not part of the voyage, right? It's you and your crew. So what would you do as a prudent master if somebody asks you to go to a war zone or a port which is unsafe?
Your Lordship, answering that question, after entering into the Charter Party Agreement, we all know that, Your Lordship, that the Charter Party has the full direction authority of the ship. Even though the crew and the captain or the master of the ship are the same, the Octa Limited, who is the Charter Party here, will have the authority to direct. If the ship owner or the ship master, Your Lordship, I beg your pardon, has not agreed to go to the Iran, the contract the contract of the Charter Party will become void. So, or the contract will not have any existence. So, Your Lordship, in the fear of breaching the contract, the entire contract, the Charter Party, the ship master has to go to Iran upon the direction of the Octa Limited, who were in authority at that time to dictate the ship, to direct the ship to go anywhere. That's why they went to Fujairah, to Fort Bangori. And just like that, they went to Iran, the IK port, upon the direction of the Queen.
Very interesting argument. So due to the fear of breaching the contract, you are ready to to sacrifice your life, and not only your personal life, but your crew's life.
Your Lordship, the political unrest was not that kind of fear of death or nothing like that. The shipmaster has, we all know that, some kind of basic common sense. So he would have checked the circumstances in Iran.
That's exactly my concern, the common sense. So if you had the common sense, the prudence, so even if the charterer says that, okay, take the ship to a war zone or an unsafe port, would you do that?
Your Lordship, the entire cargo is in the ship. Everything is in the ship, and everything is agreed upon, and everything is in the sea, middle of the sea. So the decision to go to Iran safely, even if Iran is politically unrest, he's a ship master and he has the basic things to consider. I mean, while going directing the ship to Iran, he will consider the best way to go and come back from Iran. That's what all he had to do, Your Lordship. With full respect, I say that the
Counsel, if you had refused to go to Iran to pick up the cargo, you could have had a good case by arguing that this was a direct violation or breach of CP terms. By choosing to proceed to load at a port which you argue was not a safe port, wouldn't this constitute a waiver? You cannot now argue that, no, I shouldn't have gone. You should have taken the decision at that point of time. Now, after going, you can't be heard to be saying that, no, this was a breach. You knew that this was a breach, but you chose to ignore that breach, go to BIK, load the cargo, and come out.
Your Lordship, in fact, the master of the ship is a different person, and the owner of the ship, you know that then, that the owner of the ship who comes into the contract is a different person. So after entering into the charter party agreement, the direction will be directly given to the master of the ship, who is directing the ship in the sea voyage. If I satisfied you with your permission.
Yeah, go ahead, go ahead.
We are not satisfied, but we have to move on.
Okay, Your Lordship. And the bad weather, according to NYPU rule, Your Lordship, bad weather, the claim related to the general average should be dealt with the York-Conway rule. And in York-Conway rule, it clearly states that if the jettison was done for the common safety of the entire, from saving the entire ship from a great peril, the general average should be contributed by the all stakeholders. So, Your Lordship, the jettisoning of the 650 metric ton of methanol was for the common safety. The 35-degree, the ship was listed 35-degree to the starboard side. So the from saving the ship from a great peril, the ship owner, I beg your pardon, the ship master had to jettison 650 metric ton of methanol. So, Your Lordship, it was for the common safety, and the ship master had informed the Octa Limited that the situation was such and such, and they had to make such a decision for the common safety. So, Your Lordship, there is no way that we can say the ship was unseaworthy. Two more things are there, Your Lordship, that if the ship was unseaworthy from the beginning of the voyage, so why the question arises is that why Octa Limited come into contract with this party? And the second one is, if the ship was unseaworthy due to the jettisoning, Your Lordship, why the master should have done? The petitioner, Land Opposite Council, has noted that there are two parts for the worthiness of the ships. Seaworthiness, Your Lordship, like human skill and the physical skill. So we would like to ask the question that how they measure the human part, the human skill. Is then the certificate, Your Lordship? So the best choice for the ship master was to jettison the cargo, and he himself informed through the brokers that's mentioned in the proposal, Your Lordship, that the situation was like that, and jettison was done. If I satisfy Your Lordship.
So, Counsel, what according to you is the test of seaworthiness or unseaworthiness if there is no human element involved? As they have tried to argue that there is, their argument was, their contention was not on the vessel itself, but the human seaworthiness aspect. So what is your test of unseaworthiness here, or seaworthiness?
Your Lordship, seaworthiness, there are I beg your pardon, steering wheel test, Your Lordship, and this is one of the tests which tests the seaworthiness of the ship. And throughout the world, every ship before entering into the charter party would provide with the certificates which the charter party will verify before entering into the contract. It is common, Your Lordship, because the ship is huge. So the checking of the ship by the charter party would be some difficult. That's why there are some internationally acknowledged certificates to prove that the seaworthiness. The seaworthiness may include, Your Lordship, to answer your question, the human part as well as the physical part, the mechanical part of the ship. So the ship was seaworthy according to the certificates provided at the time of the charter party. That's why they entered into the contract. Yes, Your Lordship. So after that, just because the jettison took place, they cannot argue, Your Lordship, that the ship was unseaworthy. The 35-degree, according to the ship's technicalities, Your Lordship, listing of 35-degree is dangerous for the entire ship. It's a great danger. The normal case is 20-degree, Your Lordship, for the listing of the S side, starboard, or the other side of the ship. So at that time, the rudder was listed 35-degree. So the master has to make a decision. That's what he did in the middle of the sea. So upon that act, we cannot argue that the ship was unseaworthy. If I may satisfy, Your Lordship?
So as I understand, your argument is twofold. One, the ship was seaworthy at the commencement of the voyage, and the acceptance of the ship itself goes to show the seaworthiness.
Yes,
The
Your Lordship.
second, the master is the right person on the sea to assess if jettisoning was required or not, and hence this cannot be a test of seaworthiness or
Yes,
unseaworthiness.
Yes, Your
Am I
Lordship.
right?
Yes.
Okay.
With your permission,
Go
my
ahead.
Lord. Much obliged. The court considering the issue is bound by sanctions imposed by a third country. Your Lordship, the OFAC, Office of Foreign Asset Control, publishes a list, specially designated nationals, SDN list, Your Lordship. This list is, yes, Your Lordship, Indian courts and Indian judiciary has its independence, and it's a republic, India. We all know that, Your Lordship. But SDN list, the Learned Opposite Council, while making their point, did mention a thing, Your Lordship, that the SDN list is published individuals, their names, individuals, organizations, nationals, and different companies. Your Lordship, the American agency, OFAC, makes a scrutinized test of the people, individual, companies, nationals who are funding for narcotics and terrorist activities. So the list is not an American local list, Your Lordship. We have to consider, we have friendly relation to America. That's not a thing which the court should consider, Your Lordship. I know that, but I'm mentioning that the list is of the things, companies, nationals, and individuals who are funding to narcotics and terrorist activities. Your Lordship, this is an international seagoing ship. So if for the security of the general average, the Octa Limited make a contract between our party, which is owner of the MV Moonlight ship, and the insurance company, it will affect the future of the MV Moonlight. This our party, the ship, they will have to come into contract in different nations, different sides of the world. So Your Lordship, even though the American sanction is not bound here, it will affect the future of the ship in future. That's why what we are trying to make here, Your Lordship. The SDN list should be considered with due consideration.
Counsel, there seems to be some vagueness or confusion here. A ship has its own insurance.
Yes,
that's called the Hallen machinery, H&M. That's an insurance which is taken by the ship owner. And then there is something called the P&I, protection and indemnity coverage, which is taken for liability of the ship owner for a cargo damage or a cargo shortage. In this case, we are not talking about either of these insurances. We are talking about a cargo insurance taken out by the cargo interests from an entity which is under the sanction list, which has nothing to do with this, the ship owner. The ship has no concern at all, and the ship owner has no relationship whatsoever with this cargo insurer. The cargo insurance is taken, the cargo loss has happened, the GA is put by the insurer. How does the ship or how is the ship affected? In what manner is the ship affected by cargo insurance?
Your Lordship, in the moot proposal, it stated that the security for the general average contribution was given by the insurance company, which is listed in SDN list, and the letter of subrogation was given by the Octa Limited to the insurance company. So the entire legal responsibility and the entire legal liabilities comes on this cargo matter comes to upon the insurance company. Your Lordship, so even though it is indirectly the funding between these, there is actually taking place a funding of the vessel and the insurance company. So Your Lordship, there are some difficulties in future which will arise out of this, because this ship will have to make contract in future, even though it is not a binding legal, it has no legal binding aspect, Your Lordship. There are the insurance company, since the insurance company has provided with security to the vessel, to directly to the vessel, to the ship owner, it will affect. We believe that it will affect. So the court may consider this issue as well, Your Lordship.
So just two direct, concerns here. Why do you think that this particular list by US Treasury agency is not legally binding? That's my first question. Second is, so do you think that anybody who comes into any kind of contract, direct or indirect contract with an entity listed under that particular sanction list, or does that list or the process of OFAC also says that anybody who comes into contract with the listed entities will have a problem in the future? What is the basis for your apprehension right now that we have contracted with somebody who is blacklisted?
Your Lordship, I beg your pardon for the first question.
First question is, why do you think that the list has no legal binding?
Lordship, it's American OFAC, Office of Foreign Asset Control, publishes the list. So upon the Indian courts, and it's clearly obvious, Your Lordship, that Indian courts.
Tell me, what is the scope of this list? Is it
US citizen, Your Lordship. US citizen is directly restricted to come into contract or any kind of funding with these agencies, persons, and nationals, Your Lordship.
If that is the case, then your second apprehension is completely untenable, because if sanctions only against US persons and entities, then why do you have to bother about such a contract?
Yes, Your Lordship, but your OFAC list, SDR list is considered upon by a lot of throughout the world, Your Lordship. It is directly restricting the US citizen, but in future, if the vessel, this MV Moonlight has to come into contact with another kind of American companies or any other kind of American related agencies and persons, nationals, it will affect if the past transaction of this vessel is connected with an SDR listed company. That's what we try to make here, Your Lordship. If I may satisfy you, my co-counsel will deal with the restrictions, Your Lordship.
All right.
Much obliged.
Your Lordship, am I audible?
Yes, you are.
The council solicits permission to begin. Much obliged, Your Lordship. Warm greetings to the Lordship. May I please this honorable call. This is the council on behalf of the respondent in the instant case. I'm representing the team IMC 114 and dealing with the fourth and fifth issue. Your Lordship, may I move to the arguments? The fourth issue.
Yes, please.
Much obliged, Your Lordship. The court can adjudicate on the claims notwithstanding the fact that the alleged damage occurred within its territorial waters. The charter party and terms, among the other things, call for all disputes between claimants or charters and owners to be resolved through arbitration in London. There was already an agreement between the owner of the ship and charter party that any disputes arise between them that should be solved in through arbitration in London. They entered into NYPE form was used to enter the charter party as per section 25 of which explicitly states that the general average should be adjusted as per York and Woods Rules 1994. Any disagreements over general average must be decided in arbitration at Lloyd's London according to York and Woods Rules 1994. Therefore, any proceedings pertaining to the adjudication of the issue should take place only at the place that the parties to the charter party agreement has agreed upon. So here it's clearly mentioned that they both parties, including the claimants and owner of the ship, they both entered into a clean fixture, and that said that if there is any dispute arise between them, that should be only solved through the arbitration. So hence the court cannot adjudicate on the claims, notwithstanding the fact that the alleged damage occurred within its territorial waters. If the arguments are clear, may I move to the next issue, Your Lordship?
I'm slightly confused, counsel, here because your co-counsel has already argued on this matter, the jurisdiction, the first issue. So how is this relevant? What is your contention here? You're on the fourth one, right?
Yes, Your Lordship.
Yeah.
Here, I'm arguing that the court cannot adjudicate on the claims. The court can only provide interim relief, but the court cannot adjudicate on the claim that is related to the general average.
Exactly, that's what I said. I mean, this has been heard by the court from your co-counsel as the issue number one. Okay, go ahead.
There is an agreement between both parties. Is there any disputes arise between them? They should follow the NYP
No, I'm
rule.
not on the substance. I'm not on the merits of that particular issue. Why do you have to repeat that? That's my question.
Indeed, Your Lordship. With your permission, may I move to the next issue?
So, are you agreeing that you've just repeated the first issue, or is this a different issue?
No, Your Lordship. I lead with a different issue.
So, what is that? I didn't get that. That's my concern.
The issue is the court cannot adjudicate on the claims, notwithstanding the fact of that the alleged damage occurred within its territorial waters. Here I am saying that the court cannot adjudicate on the matter. The first issue dealing with the jurisdiction.
Please
Okay, this
differentiate.
for jurisdiction.
Please
Okay, go ahead.
differentiate. Yeah.
Your Lordship, may I move to the fifth issue?
Okay.
Much obliged, Your Lordship. The fifth issue is dealing with the provision of the Arbitration Act, not exclude an action in rem from its purview as not arbitrable. As I already said, and they are both parties are entered into an agreement, and so it's clear that here there is right in personam. So there is we can understand that here there is no right in rem. So the arbitration, they should go for the arbitration for solving the right in personam. Here we are giving some cases. The Supreme Court in Bozalan case stated that the dispute relating to the subordinate rights in personam arising from rights in rem have always been considered to be arbitrable. In another case, the Bombay High Court, in case Eros International Media Limited versus Telemax Links India Private Limited and others, it was held that the overlying copyright is a right in rem enforceable against the world at large and it is arbitrable. Therefore, some disputes in relation with an action in rem are qualified for adjudication and settlement by arbitration. Here it's clear that the disputes arising between them, or here there is a violation of right in personam. So the both parties should go with the arbitration as per their agreements from Lloyd London. They should solve this dispute. Here it's humbly submitted to this honorable court to address the petition under the Admiralty jurisdiction of India. If the issues are clear, may I move to the prayer, Your Lordship?
So you have given us two judgments, I think both from the Supreme Court. One, yeah, anyway, so two judgments. So two judgments speaks of two things, right? So in the first judgment, you said that there is a subordinate right in personam and therefore it is arbitrable. And the second judgment, it says that certain rights in rem are arbitrable. So which, according to you, is the relevant decision for you here? Because are you saying that this particular action is an action in rem or a personam?
This particular action is action in persona.
So then why do you have to cite a case which says that action in rem is arbitrable? If you are saying that this is a right in personam, just explain to us that how is it different from a subordinate right in personam as opposed to a natural right in personam?
The rights related to ship always include a right in rem, but here we can say that here we cannot clarify that there is no right in rem. Here the right in rem also erased due to the ship arrest. But here we can also say that there is an agreement between both parties and two parties are included, and so we can conclude that there is also a right in persona. If there is a violation of right in personam arise, they should go with the arbitration.
Okay.
If there is no any further doubts, Your Lordship, may I move to the prayer?
Yes, go ahead.
Much obliged, Your Lordship. Wherefore, in light of the facts of the case issued, raised, arguments advanced, and authorities cited, this honorable court may be pleased to find that in view of the arbitration clause in the charter party, the exercise of admiralty jurisdiction by the court is not valid. The declaration of general average is legally sustainable since the vessel was seaworthy. The court, considering the issue is bound by sanctions imposed by a third country, the court cannot adjudicate on the claims considering the fact that the alleged damage occurred within its territorial waters. The provisions of Arbitration Act not exclude an action in rem from its purview as non-arbitrable and pass any such order that this honorable court deem fit in the interest of justice, equity, and good conscience. If Your Lordship was satisfied, may I end up this?
Sure.
Much obliged, Your Lordship. It was immense pleasure to deal with the arguments in front of this honorable court. Much obliged, Your Lordship.
Both the teams have presented their initial arguments. If Your Lordships may permit, can we proceed to the rebuttal session?
Sure.
Since IMC 104 have exhausted their speaking time, you may seek the permission of the court to proceed with the rebuttal.
Your Lordships, the council requests 2 to 3 minutes of this court's valuable time for the rebuttals.
Yes, please.
Much obliged, Your Lordships. Your Lordships, the first point of rebuttal in the present case would be my learned counsel for the respondent stated that counterclaim should not be adjudicated in the court but should be settled in arbitration, Your Lordships. Your Lordships, it is humbly submitted before the court that if the respondents don't want the counterclaim to be adjudicated in the present court, then the respondent should not have filed the counterclaim in the first place, Your Lordships. The counterclaim of sustainability of journal average should have not been filed in the first place, Your Lordship. Secondly, Your Lordship, the learned counsel also cited the rule D that gives leverage for the sustainability of journal average, the rule D of your country.
Just a doubt. Did they actually make such a contention that the counterclaim should not be adjudicated by the court?
Your Lordships, they did. They stated that it should not be adjudicated by the present court and should be referred to arbitration. It was the fourth claim.
Did they argue that the counterclaim, did they mention about the counterclaim or something else? That was my concern towards the council also.
Your Lordships, as per the amount of knowledge the speaker has gained, it was that the counterclaim is not permissible and should be, it was that the claim is not permissible and should be referred to arbitration, Lordship. But the fourth issue does deal with the counterclaim.
Maybe, but I did not hear, at least we did not hear the counsel for the opposite party arguing for a counterclaim. No problem. Yeah.
Indeed, Your Lordship. Your Lordship, secondly, the counsel for the respondent cited the rule D of your Canfor rules, Your Lordship. It does give leverage for the sustainability of general average. But the last line, it is, Your Lordship, it is important to focus at the last line of the rule D, that clearly states that nothing in this rule shall prejudice any remedies or defenses which may be open against or to that party in respect of such fault, which clearly means that the claimants in the present case have the right to remedy, to sustain remedies, Your Lordship. Next, Your Lordships, the councils also stated that the normal degree of the what do you call it, port, and it was 20 degree. But Your Lordships, it was cited by the council that as per the SOLAS International Convention for safety of lives at sea, it should be 35 degrees starboard. That is a normal, Your Lordships, tilt. But the council stated that it was 20 degrees without any backing. That is all, Your Lordship.
Court officer, I think they're done with the rebuttals.
Our rebuttal time is 5 minutes. Respondent side may proceed now.
Your Lordship, yeah, backing from rebuttals. Your permission.
Okay.
Yes, please. Go ahead.
What did you say? Did you ask the permission, or you don't want to proceed with the rebuttal?
Yes, that's Your Lordship. We don't want to proceed with your rebuttals here.
All right, all right.
So with the permission of the court, let me inform the team that it is the time for tabulation. So teams may please leave the court for the time being until the respective team managers direct you to re-enter the court. Thank you, everyone. Judges, please remain in the court.